not because we are diligent, not because of any goodwill of mine. It's just because we have Shabbat restrictions, and the university will shut the doors at around 2 o'clock. So prepare yourself that that's the upper limit of our day-to-day. I'm very glad and excited to introduce Professor Sam Isacharoff, who will give our second keynote speech this morning. I have known Sam since, I think, 2008. He was a teacher and a mentor of mine, and I'm very grateful for him for accepting our invitation and for coming all the way from New York. Sam is an authority in many fields, in constitutional law and in civil procedure. He specializes in complex litigation. He has a wide range of interests and specializations. I take it that he's too well known to need any introduction, but this is a ritual which we need to go through. So I'll read a few lines. So Sam is Rice Professor of Constitutional Law at New York University Law School. His wide-ranging research deals with issues in civil procedure, especially complex litigation and class action, law and economy, constitutional law, particularly with regard to voting rights and electoral systems. He is one of the pioneers in the law political process, where his Law of Democracy casebook, co-authored with other people, and dozens of articles have helped to create a vibrant new area of constitutional law. He is also a leading figure in the field of procedure, both in the academy and outside. He served as the reporter for the Principles of Law of Aggregate Litigation of the American Law Institute. He graduated from Yale in 1983. He worked for a number of universities, from the University of Texas, and later on at Columbia Law School before he moved to NYU University. So without further ado, please, Sam.
Thank you, Rabia. I've known Rabia for 10 years. I met him in the halls of Madeline College when he was still just starting as a graduate student. I've known him for 10 years, and it's always been a pleasure until today, because today, for the first time, he stole my lecture notes as he left. So if I could have those back.
Oh, of course. I hope you would not notice that.
All right, I want to speak today on a topic of not whether to aggregate, but how to aggregate. And this is a talk about where I think American law has gone at this point. And I'm going to focus on American law today, although I'm really going to be talking about some comparative issues slyly along the way. So I want to begin with an event that took place at NYU a couple of years ago. It was the 50th anniversary of the approval of Rule 23, Modern Rule 23 of the Federal Rules of Civil Procedure, which were created in 1966 in their modern form. And we have the advantage of at NYU of having among our colleagues Arthur Miller, who is the last surviving person who participated in the process of creating those rules in 1966. In the words of our leading social commentator, Lin-Manuel Miranda, he is the last person who can say he was in the room where it happens, right? He was there. And so I interviewed him, and much of the interview was about the history of the discussions, the negotiations that went into Rule 23. But at the end, I said, I'd like to talk to you about 3 modern cases that symbolize where the law of class actions has gone, and ask you what would have been the reaction of the people in 1966 if you told them that what they were creating then to deal primarily with Brown versus Board of Education and our civil rights revolution in the States would be used in this kind of an expansive way. And it was not just really about the people in the room at the time, it was about you, Arthur Miller, what you've seen the evolution. Where, at what point did it go beyond anything that you would have imagined was possible? So the three cases that I want to talk about, I'll start with the first one, and following my friend Jack Coffey, I'll disclose I've been involved in many of the cases I'm going to discuss, so you take that in whatever way you'd like. The first case was the Deepwater Horizon, the British Petroleum spill in the Gulf of Mexico. And here's a case where, at the end of the day, $15 to $20 billion was paid mostly through the agency of a class action by British Petroleum. There was a huge remediation effort in the Gulf of Mexico. There was coordination between federal and state authorities. There was a private dispute resolution system run by Ken Feinberg. There was a class action mechanism that represented most of the small businesses that were affected by it, some not so small, that were affected by the spill. And the question was, what would have been the reaction in 1966 if you knew that there could be something like the Deepwater Horizon litigation? And Arthur's reaction was, in 1966, we could never have imagined litigation of this scale. In order to get to this point, there had to be the training of generations of lawyers and judges in how to handle complexity of this kind. But that's a question of scale. In terms of the actual organization of the litigation, he said this would not have been that difficult. There were questions of coordination between private enforcement and public agencies, but in 1966 we already knew that from the antitrust domain. We knew that there could be such coordination across private-public lines. There were administrative mechanisms for damages, but already in the 1960s, we were starting the Title VII cases, the employment discrimination cases, and we knew that there was a difference between the liability determination and some kind of quasi-administrative mechanism being used for damages. And so it's shocking in terms of how complex and the size of it, but it wasn't really a conceptual challenge from what we thought about in 1966, given the experience that the courts already had with antitrust cases. So the second case that I raised for him is what's up on the slide here. And if you take away anything from this conference, other than you get a tag and you get various things, and you'll have souvenirs undoubtedly, but if you take away anything from this conference, it is this image. And if you want to criticize the American wolf and all that kind of nonsense that I have to put up with every time I go out of the country, you take away this image. What is this? Yeah. Well, it looks like Judge Dow, I think, can I call on you, or are you going to tell us what this is? So this is an airplane.
I got that part.
You got that part, okay. That's an airplane. You may notice that that airplane doesn't appear to have a lot of room to take off and maneuver there, and there's a reason for that. That's a mothballed airplane. That's an airplane that's sitting in the desert, abandoned, right? What's next to it? Tens of thousands of Volkswagens. Those are cars parked in the desert. There's an entire parking lot of the Pontiac Dome, which is the abandoned football stadium outside of Detroit, filled with Volkswagens. In a one-year period, $10 billion was paid by Volkswagen to get all of its Dieselgate cars off the road in the United States and substitute brand new cars, plus about $5,000 per person, to every American who bought one of those bad cars. Where in Europe is the parking lot that looks like this, right? It doesn't exist. Where in Sao Paulo is the parking lot that looks like this? It doesn't happen anywhere unless you have the private enforcement mechanism. That's the lesson of Volkswagen. Ariel yesterday said that this is the landmark case of our time. If it's the landmark case of our time, that's the picture to take away as what private and public remediation efforts can do. And until there are pictures like this in Europe, I don't want to hear about the American wolf. Yes, we paid $175 million to 99 law firms for an extraordinary amount of work. That's less than 2% of the recovery to the class as a result of the work of those lawyers. You think 2% is high transaction cost to get this? Where is the regulatory alternative that the Europeans have gotten instead? So this is the Volkswagen case. So back to Arthur Miller. So I asked Arthur, if this is the test case of our time, again quoting Ariel, what would the people in the room in 1966 have said about Volkswagen? And he said, again, the scale is beyond anything we could have imagined. But this case is not that shocking in 1966 because there was already a model for injunctive actions. This was heavily an injunctive action. There was already a model for coordination with the regulatory agencies, and we knew from antitrust that you could work between private lawyers and the Federal Trade Commission, and in fact, in the Volkswagen case, the private lawyers coordinated with the Federal Trade Commission, with the Environmental Protection Agency, with the California Air Regulatory Board, and so all of that was in some sense, or at least it could have been anticipated in 1966. So the third case I asked him about was the NFL Concussion Case. This is the case involving brain damage as a result of playing American football. In American football, it turns out you hit your head against other people constantly, and it's a shock of modern science that we were able to determine that getting hit on the head repeatedly, a lot, hard, over the years is not good for you. Who knew, right? I'm sure it came as a surprise to everybody. But Arthur said that one we never would have anticipated. That one was shocking because this was about 20,000 people with potential personal injury claims. And this is something that would not have been anything within the contemplation. There's a famous line in the advisory committee notes in 1966 that says, we're not doing anything to allow for mass tort claims. And so now all of a sudden you have what we would call a mass tort. This is personal injury. There's really no other component to it. These are retired players, so there's no injunctive remedy while they're still playing. They're all done. And their relation with the National Football League, the authority that runs American football, is simply that of victims of past misconduct or alleged misconduct, very difficult to prove, but alleged misconduct. And so that, he said, would have been absolutely shocking. Now, there is certainly doctrinal support for Arthur's view. That is, the leading cases in the United States from the Supreme Court on the role of the class action mass tort have been highly negative. So the two leading cases are from 20 years ago, the Amchem case that Jack Coffey referred to yesterday, and the Ortiz case, its companion case. And in Ortiz, we had Justice David Souter saying that there's something wrong with a mass asbestos personal injury case. The world is supposed to turn on having one client, one lawyer, one case. And this is a departure from the way that we conceptualize mass torts. And so if you have both the doctrine running against something like the NFL concussion case, and you have the history of the rule saying this is exactly what we don't want to unleash, it's kind of extraordinary that 20 years later, you get 20 years after Amchem and Ortiz, and 50 years after Rule 23 went into effect, you get something like the NFL concussion case, which is a class action settlement of all 22,000 retired NFL players claiming that they were injured as a result of the malfeasance of the overseeing body of American football. So the question then is, for me, and the question I want to pose to you today, is how is it that we got to this point? And the key insight, and again, Jack Coffey undercut me a little bit because the key insight is one that he put up on the slide yesterday, which is nature abhors a vacuum. And what nature abhors is also unacceptable to lawyers. And entrepreneurial lawyers in the United States have filled in the gaps that were left open in 1966. And so the question is, how do we get from 1966 or 1998 and 99, the Amchem and Ortiz cases, to the point at which the courts can accept something like a mass resolution of personal injury cases arising from highly idiosyncratic harms to each individual player and deal with that on a collective basis? I think that the answer is the experience, the wisdom that has been achieved through the actions of lawyers and judges in learning how to handle mass cases, learning how to deal with aggregation. Because while it is true that for an entire generation following Amchem and Ortiz, it was believed that the courts were not capable under the class action rule of handling mass torts. And that was the lesson. That's what we told our students. We said the courts are drawing the line because under our Rule 23, mass torts always involve the individual harm. The collective question cannot predominate, this magic word of predominance that dominates so much of our litigation under Rule 23. It just can't be satisfied in the mass tort context until it can be. And what happened in the intervening 20 years? Where did all the mass torts go? The Supreme Court said categorically, pretty categorically, we're not going to use Rule 23 for this. But what we learned was, okay, we will not use Rule 23. We will use other mechanisms of aggregation because these are still mass collective harms, and the system and our legal system can neither handle them on a one-by-one basis nor ignore them. So concretely, what did that mean? Well, first of all, in the asbestos context in which Amchem and Ortiz arose, which was our first great mass tort, the asbestos cases, what became of all those cases? Well, it turned out we have a little corner of the bankruptcy code called Section 524G, a little obscure provision that nobody had ever heard of, that was a private bill so that Warren Buffett could manipulate his stock investments in Johns Manville. And then all of a sudden, it allowed for asbestos bankruptcies on a special carved out procedure that shockingly looks a lot like Rule 23. It looks like Rule 23 in the sense that it puts all the cases together. It creates a voting mechanism to allow a legitimate governance structure. And then it says, package them all together, take them through a bankruptcy court, and then at the end of the day, set up a grid so that everybody gets paid on a pro rata basis depending how much money is available to you. That was the way in which we resolved the asbestos crisis in the United States, in the American courts. It looks functionally like Rule 23. It operates functionally like Rule 23. It has a leadership structure for the plaintiff, so it looks like class counsel, and it worked. It got the job done. It got the asbestos cases through the court system, and it created some confidence in lawyers and judges that we can handle even the nastiest of mass torts. And asbestos is the hardest one, because asbestos, you can be exposed one day and have a manifestation 50 years later. So it's what we call a long-tail tort. You don't know how many people have been exposed. It was used all over the United States. There's massive numbers who've exposed, and even today, 30 years after we banned asbestos or got it out of most workplaces, almost 40 years, we still get about 3,000 mesothelioma cases a year coming into the American system, new cases. So it's a nasty, nasty tort to have to handle, but we did it. The second thing that happened is, and there's an excellent set of articles by Maggie Lamos of Duke Law School on this, we started to expand the role of the state, acting as if it were class counsel. And we started to transform the role of what's called parens patriae litigation to allow more state intervention to assume a litigation role vis-a-vis individual claimants in mass harms. Now, what's interesting about this, and you take, for example, cases like MTBE, which is an additive to gasoline to help improve the mileage when you have unleaded gasoline that got into the water system, you started having mass cases brought on behalf of water systems, homeowners, by local authorities. Now, this is not the classic this is not the classic regulatory action that you're well accustomed to in civil law countries. This is not the state assuming a regulatory capacity, saying we have the right to regulate this process. This is the state saying we are going to stand in the shoes of our citizens as litigants. And so we are going to assume regulation by litigation authority, not regulation through the normal agencies of the state type regulation. So this was a change in the conception of the role of the attorneys general, and it filled in some of the void left open under Rule 23. We had an explosion of private mechanisms of aggregation. The referral doctrine in the United States started to drop down, so you could refer cases and get paid by them. So you had lawyers advertising, soliciting clients, and then sending them, referring them as we call it, to the firms that were capable of prosecuting those claims. Some of that now is being picked up by litigation finance, which is the brand new frontier in American litigation. Litigation finance is a way of aggregating claims. It's a way of bringing them together through private actors. So you have private aggregation, you have state aggregation through the Participatory, and then in bankruptcy you had a special other kind of aggregation. But the most important area of new aggregation after Amchem and Ortiz was the explosion in what we call multi-district litigation in the MDLs. What is the MDL process? It was a statute that was passed in 1968. It got no fanfare. It was not paid much attention to. It was thought to be a way of figuring out how to coordinate if you had antitrust cases filed around the country so you could get the discovery done efficiently in one place. And all of a sudden, we have an explosion of MDL cases. To give you a statistic, somewhere between 40 and 50% of the docket of the federal courts in the United States, the civil docket, is MDL cases. So we have used the MDL process to handle mass harms. What does that mean? It means if you actually look not at the number of cases that are called MDL1, MDL2, each one gets assigned a number, we're up in the couple of thousand by now, but if you look at how many filings there are in these MDL cases, somewhere around 80% of the docket of the MDL courts is what we would call mass harm cases. So we have taken the void left by Amchem and Ortiz and moved it into the MDL process. And what happens then in the MDLs? Well, you get a judge who will handle the case collectively, who will oversee the appointment of counsel, who increasingly will oversee attorney's fees, who will increasingly have to determine what's a fair and reasonable resolution to be able to close out these kinds of cases. In other words, you have judges assuming roles that look like our classic class action judicial role in a slightly different setting, in the MDL setting. And so you have yet another expansion of the class action, or class action-like device. In other words, our court system is becoming accustomed to aggregation. Finally, we have a mechanism that was left open by the rule. It's very poorly articulated. It's what's called the issue class, Rule 23C4. And it was basically never used. And then in recent years, courts have started to say, why can't we use this? And the most important opinion, early opinion, was by Judge Posner in a case coming out of Wisconsin. And the question in the case was, there was a contamination of an aquifer, and there were a group of homes around the aquifer, and if the contaminant was the result of a particular defendant's leak from an industrial site, if that's true, then everybody was going to have a claim against that defendant. If the plume did not come from that source, then nobody was going to have a leak. And Judge Posner said, why don't we just try that issue? Isn't that going to resolve everything? Because if we determine whether or not there's liability, then everything's going to settle from that, or all the defendant's going to win all the cases. Why in the world would we have multiple trials on this same issue of whether the plume was the source of the contaminant, of whether the source of the plume was, in fact, the alleged wrongdoer? This started to take hold, and very recently the Sixth Circuit, in another case involving a contamination plume, again wrote the most expansive opinion that I've seen so far on the use of issue classes. The Supreme Court last week denied certiorari review on this, and what you're getting is an aggressive new use of issue classes in just about every circuit in the country right now. And so we're getting court acceptance that you can manage cases through this kind of a mechanism. Now, why is this happening? Well, as a doctrinal matter, a lot of this owes to an unanticipated result of an amendment to Rule 23 about 10 years ago, and that was the introduction of Rule 23F that facilitated appeals. So for the first time, we're getting a lot of appellate law. It's not coming from the Supreme Court. The Supreme Court's been pretty passive realistically in the class action domain. It's been aggressive on arbitration instead of individual claims and consumer rights. But other than that, it's been relatively passive. But you've seen an explosion of new law from the courts of appeals. And part of that is because they now take interlocutory appeals on the class certification issue, so they see these questions. But I think that there's a broader issue, and that is what the courts are starting to realize they have to do. And there's a couple of Third Circuit opinions by Judge Anthony Sirica, which I think actually lay out what the challenge is. In one opinion, in a case called Combustion Engineering, which had to deal with bankruptcy and asbestos under the bankruptcy code, Sirica said, you know, it's true that Amchem and Ortiz, which demanded that similarly situated people be treated in like fashion, were about Rule 23, mass torts, and this is a bankruptcy. But Judge Sirica said, the Supreme Court's requirement of fair treatment for all claimants, a principle at the core of equity, also applies in the context of this case. So Judge Sirica introduced the idea that it didn't matter which silo you were in. Were you in bankruptcy, MDL, class action? The treatment, the ultimate goal under the principles of equity that must guide our courts, was the same in each context. Subsequently, in another case involving antitrust, Judge Sirica wrote that the experience with the asbestos cases, with the mass tort cases in MDL, is going to force the courts to re-examine Rule 23. It's going to force the courts to come to grips with whether Amchem and Ortiz got it right at the end of the day. That's the question. It's not that they said this. The question now, 20 years later, is did they get it right? And what Judge Sirica said was that the class settlements in mass torts remain problematic, and they've led some practitioners to abandon the class action device. And he said that's a mistake. The class action device, and I'm reading from his opinion, and this is a case called Sullivan, and the concept of the private attorney general are powerful instruments of social and economic policy. Despite inherent tensions, they have proven efficacious in resolving mass claims when courts have insisted on structural, procedural, and substantive fairness. And then in what's perhaps the nicest distillation of what should be the aim in all mass harm representation, he said, the goals are redress of injuries, procedural due process, efficiency, horizontal equity among injured claimants, and finality. That has to be the object of any legal system dealing with mass harms. They have to get closure, they have to have equitable treatment of similarly situated people, and they have to have procedural due process, meaning there must be transparency or there must be judicial oversight. And the problem with the private aggregations, the problem with the MDL process, and even the problem with bankruptcy was that it was too obscure in its organization, and so there was not enough of the procedural fairness that we associate with Rule 23. There was not enough rigor in the mechanisms that were being used. This takes us back to the NFL case. And in the NFL case, two important considerations followed from, again, this is in the Third Circuit once again, so it's following directly on the jurisprudence that Judge Sirica had articulated. And this is what Judge Ambrose says in the NFL case. one of the principal concerns driving AmChem's strict analysis of adequacy of representation was the worry that persons with a nebulous risk of developing injuries would have little or no reason to protect their rights and interests in the settlement. So in other words, here was Judge Ambrose articulating the core of AmChem as being an agency problem. That is, it's a problem that we don't trust the mechanisms of oversight of the individual representations. You don't have one lawyer and one client the way that Justice Souter would have it. How do you know that the lawyers are doing a good job? And what's happening in the courts right now is that we rarely see the class action where there's one named client, one lawyer, and in fact, everything is done by the lawyer with no transparency, no accountability. That was the concern that the court articulated in AmChem. Look at the facts in the NFL, says Judge Ambrose. We have evidence in this case the concern is misplaced because many retired players, including many who are not injured now, who have not yet manifested injuries, have already taken significant steps to protect their rights and interests. Of the 5,000 players who sued the NFL in the MDL proceeding, class counsel estimate that 3,900 have no manifest disease of the compensable level right now. In other words, you have 3,900 people who want protection going forward, and they are represented, says Judge Ambrose, by over 300 sets of other lawyers. So you have this combination of private aggregation through individual representation, collective aggregation through the MDL process, and now you have the transparency and accountability of the class action mechanism being used. Under those circumstances, says Judge Ambrose, we have little problem saying that the interests of these players were adequately represented. Not simply by the formality of Rule 23, but by the way that our courts are operating, by the centralization of these claims through the MDL process. I wrote an article with Elizabeth Cabraser about a year ago, or 2 years ago, in which we tried to drive home this point and talk about something that we call the participatory class action. That is the class action that grows out of the MDL consolidation, so you have a mix of individual representations, absent class members, all kind of coming together here. And Cabraser went back, and she's one of the leading class action lawyers in the United States, went back through her personal files of the last 20 years. And she said in the last 20 years, in all the cases that she's been class counsel, and she was the lead counsel here in Volkswagen, in all the class actions in which she was lead counsel, there was not a single one which was not an MDL, which meant MDL means lots of individual cases are being aggregated. So that means there's lots of lawyers who are overseeing the process, and that should give judges confidence. When there's many lawyers who are vigilant in the process, the courts can stand down a little bit. It's not just the courts that are the fiduciaries, it is also all these other lawyers and all these conflicting interests that come together. Now, let me conclude by saying that why is this happening and how should we think about it? Well, I think that it is a question of our legal system coming to grips with the fact that we live in mass society and that we have to aggregate. There is just simply no way around it. And 20 years ago, David Shapiro, who was then a professor at Harvard, started us on the pattern of speaking of class actions and other aggregative devices as the creation of an entity, something like the creation of a limited purpose corporation. And the entity idea is one that says you have aggregated, you have come together, and you want to achieve a certain gain by that, and at the same time we have to start worrying about agency costs and the question of governance. And so for those of you who know my work, I tend to push heavily outside of law to get models of how to think about the governance problem, how to think about this. And what I want to suggest to you is that what we're going through right now in class action law is actually a reflection of a long-standing debate in political theory. And so you'll have to, I know this is a procedural crowd, but this won't hurt you, so I promise. So what justifies giving a collective body authority over individuals. That's ultimately what we're dealing with here. How do we know that it's legitimate to have these kinds of aggregations? Well, in classic terms, we have the spirit of John Locke with us. And John Locke says this is an individual autonomous right, and therefore, in order to legitimate somebody else having the right to make decisions for us on our behalf, somebody else having the right to monopolize the forms of violence, there has to be consent. And the consent has to be in a contractarian way. Sometimes we debate about whether there's a social contract. And much of political theory about the legitimacy of democratic governance is about how do we assess the social contract. And I want to suggest that a lot of the writing on class actions has followed this form. It is, how do we know that we can trust the representatives? How do we control, how do we police the agency costs? How do we know that the people who are the putative representatives aren't going to sell you out, aren't going to take more attorney's fees in order to deliver closure? How do we know that this is proper? But in political theory, there's another role of the state that is a little less glamorous than the realization of our collective will and our consent. And that is a tradition that was begun with David Hume, and most recently has been pushed heavily by Russell Hardin and other political theorists who say, hey, wait a second. You're telling me somebody consented in 1789 to the American government, and I was born in Argentina, and I came to the United States when I was 5, and I consented by landing in Miami at 5 years old? You know, this is a nice story, but you know, it's got some holes in it. And their argument is, forget the consent side. One of the reasons that the state is legitimate is because it provides a coordination of social problems. It allows us to have a set of settled expectations. You can go back to Hobbes for the importance of these settled expectations. And it lets us coordinate our lives in a way that's advantageous. And if you go into the debates in constitutional law, for example, there are those who say the most important thing is consent and the process. And then you look at the French Fourth Republic, which was the most democratic, legitimate government, constitutional government in the history of man, because it was established by a parliament, it had parliamentary sovereignty, and it lasted 12 years because it was a complete catastrophe. But it had perfect democratic pedigree. On the other hand, you look at Japan. You have a constitution that has no democratic pedigree. It was imposed, largely imposed by Douglas MacArthur, but it has served to coordinate Japanese state policy in a way that even to this day, it's almost impossible to amend the Japanese constitution. Every effort has failed, including by the current government. And the reason is it works. It gets the job done. It has allowed Japan to go forth and prosper. And so when we start thinking about less exalted questions and what legitimates the state, and ask the question, what legitimates the collective aggregate representative? What legitimates an MDL process? What legitimates a class action? I think that too much of the academic focus has been on the contractarian side. What is it that permits these agents to act? And not enough of the academic attention has been on, how's this working? What kind of results are we getting? Are we getting this? Are we getting this kind of resolution? Because if we're getting this kind of resolution, I would suggest that that's worth a great deal of attention. And the courts understand this, I think, better than the academy does. I think the courts have moved on from the question of worrying exclusively about the attorneys and the attorneys' fees. It's true that because it's in the United States, it's all driven by entrepreneurial lawyers, we're going to fight over money all the time. And every judge who has one of these cases knows at the end of the day, there's going to be a money fight, and it's going to be ugly, and it's just the cost of doing business. And all right, so that gets a lot of attention, and we have all kinds of websites that talk about the perfidy of lawyers, and so they can always broadcast this sort of stuff. But talk about the results. And so that takes me to the final point, which is, what have we learned from this? And I think that what we've learned is that we can actually use a multiple forms of aggregation to achieve the kinds of effective representation that were not available to us in the model of one-by-one litigation. We know that we can handle it. We know that our courts are capable of doing it. Let me give you one example. There's a case out of Texas that started in the 1980s called Semino. Semino is a case of 3,000 asbestos victims who were put together and joined in front of, they were all in front of one judge in Paris, Texas, in Tyler, Texas, Robert Parker. In the mid-1980s, Semino went to the Fifth Circuit under the name of Raymark versus Jenkins. And for the first time, a court of appeals said it's okay to have a class action to resolve certain kinds of common issues. It was our first major issue class in a mass tort setting. And that got a little bit. Then came the next piece of Semino, says, okay, now let's try all these cases of class action. Court said no. Fifth Circuit said no. Then the judge said, okay, I'll try them by joinder, by another device under our rules of civil procedure. Fifth Circuit said no to that. Ultimately, all those cases went into bankruptcy with everything else. It didn't get resolved in bankruptcy, and then through the bankruptcy, they finally had an arbitration of all 3,000 claims. So the beauty about Semino is at one point it was an issue class, at one point it was a putative class, at one point it was a consolidation joinder, at one point it was a bankruptcy proceeding. It ended up as an arbitration, but we got it done collectively. And the irony is that my colleague Arthur Miller argued the first Semino appeal in the Fifth Circuit. 25 years later, he won the case finally in arbitration. And so, of course, I said, you know, if you'd done it right the first time, you know, you wouldn't have had to waste all this time. So let me conclude then with the biggest challenge right now for us. We have an opioids epidemic in the United States. And the question is, what are we going to do about this? It's a challenge in litigation terms beyond, I think, anything we've experienced in the court system. It's multiple defendants, not one defendant like in BP. It's uncoordinated claimants, and you have a lot of the claimants are cities and counties and Indian tribes and states, which means you have sovereignty issues and different limitations on the ability to use class actions for states and so forth. You have some prior aggregation where states say they have the authority to speak for their cities and counties, and some states where they don't have that authority. And you have a scope of damage that's beyond anybody's wildest imagination. And so there's just no way that there's enough money in all the defendants. In fact, there's not enough money in the United States to pay for all the remediation that's necessary in the opioid situation. So what do we do with that? Well, a lot of individual cases got filed, a lot of putative class actions get filed. We have MDL, we've MDL'd all of these, we put them in an MDL to a single judge in Cleveland. We have putative class actions, we have some companies that will likely go into bankruptcy very soon. We will test all the mechanisms that are possible in order to figure out which one works, and probably we're going to use all of them. Probably we're going to use some combination of MDLs and bankruptcies and class actions to try to get this resolved. It poses a tremendous challenge for the courts. And here's the challenge, though. The challenge is, realistically, and you should all be thinking this, what kind of insane system would put a social crisis like this in the courts in the hands of one judge and say that this is going to be handled through the litigation process? Well, Eric Kramer spoke at the beginning of the conference yesterday about the breakdown in confidence in our democratic institutions. And that, I think, is really the story of aggregative procedures in the American court system. This is what Judge Holster, the judge in Cleveland who's handling all the opioid cases, said. Federal court is probably the least likely branch of government to try and tackle this. But candidly, the other branches of government, federal and state, have punted. It's here. And that's the right reaction. This should not be a matter for the judicial system. But what we've learned through the process of all of these experiences in aggregation and resolving mass problems and being able to do it competently, including, and I keep going back to this image, take this image with you. That airplane's not taking off and those cars are not going anywhere. So take that image with you. What we've learned is that through aggregative procedures with some procedural rigor in the court system, we have started to use the courts as a reservoir of coordinated problem solving in the United States. Is this better handled by the political branches? Certainly. Come visit our Congress at some point. And, you know, but it's not just ours. Go to Parliament. Go to the National Assembly. Go to any, you know, go to any parliamentary body in the world right now and try to get resolution of a mass crisis. Where has the German Bundestag been on the Volkswagen case? Where is the remedy in Germany? Right? Okay, so you don't want to put it in the courts like the Americans. Fine, the American wolf. Where is the German parking lot? Right? So, as with the question of constitutionalism that I introduced, this idea from David Hume on forward, on the virtues and the importance of coordination to solve political problems, I think that the challenge that the courts see in cases like Volkswagen, like British Petroleum, Deepwater Horizon, like the NFL concussion, is a need for a coordinated resolution. And I may be getting a little Panglossian in my old age, but I actually think we're doing a pretty good job of it, and I would put our capacity to resolve these issues up against that of any other country in the world right now. Thank you very much.
Thank you very much, Sam, for this really fantastic speech. Perhaps we can take a quick round of questions if there are any. Please, Yanka.
So thank you very much for this very inspiring and thoughtful speech. I just have three very quick comments. The image is great.
This won an award, National Geographic's Best Picture of the Year. So.
Thank you for sharing with us. I was just wondering, do you realize that the fact that you are able to have this picture exists only by virtue of the rest of us maybe having a less efficient systems? So if you would have that, your parking slot would probably be half or 1/3.
Okay, if I didn't express my appreciation, thank you, Yannicka, for being so generous with us.
So watch out what you're wishing for, that's what I want to say. Secondly, the regulation by regulator via litigation, I think that's a very interesting trend that we will not see in Europe, unfortunately, so I'll be very curious how that will go in the United States. And finally, I couldn't agree more with you about focus on output and results, which makes me wonder how come the United States still doesn't have an obligation to register outcomes in terms of take-up rates and everything, and makes me wonder which lobby prevents that. So.
Okay, let me take yes, I'm always appreciative for what Europe gives to us, the benefits of liberty and most of their wealth, and I'm happy. But on the serious and good food, yes, yes, yes. Ramo is a much better cook than I am. But on the serious points, the last one is actually the last two are quite fascinating. The regulation by litigation, look at the opioid crisis. We don't have a federal government that's capable of coordinating. And the people who are litigating in opioids are primarily governmental entities. They're cities, they're counties, they're Indian tribes, they're states, and they don't have the capacity to come to any kind of closure, to cut a deal with most of the defendants, to organize a system of recovery as big as they are. Even the state of California, with 30% of our national income and so forth, can't handle this kind of case, and so they come to the court system. The states, all these public entities are coming to the court system and some of them saying, and treat us as a class member, treat us as a class action. It is an indication of where we are. On the final point, there is an examination by the rules process in the United States, and you happen to be sitting next to somebody who has something to say about this. One of the things they're looking at is the MDLs, and I have had the opportunity to go and address all the MDL judges in the country on several occasions, and every time I go, I say, you have to start registering outputs. You have to be able to demonstrate to the critics, to the European critics and so forth, what does it actually cost? We need transparency and accountability, and the good judges are doing that. So you can go on the VW litigation website, you will see how many cars were remediated, how many cars were taken off the road, you will see what the attorney said, you will see what the total transaction costs were, and you will see a model of both transparency and accountability for on the output side. And I think that it's just a time delay that we haven't done that yet. I don't think it's a lobby. I think it's just, there's just a sense of stasis in the legal system that we haven't done it before. Why should we do it now? I don't think we're pushing against a major lobby there. We just haven't gotten there yet.
Sam, I will certainly not defend Germany. So,
no, because you're an Italian.
Yeah. But also in Italy, the cars are driving around. So please. No, but you know, decades ago, I worked on double standards. Yeah. And my question is, what will happen to these cars? Where are they exported to? Yeah. And where is that money going? Yeah. Because it's wonderful. I would like to see each year this photo, and you will see the number of cars diminishing. Yeah? And where are they going? Yeah? I think that's also a problem that we should have in mind.
Yes, and we had that in mind in the settlement, and I was involved in this. And the demand was, you will not export these to Lagos or wherever the market is. You will either remediate these or destroy them. They will not leave the United States.
That's part of the settlement.
That's part of the settlement. We took this up as an environmental challenge, and it was not just a matter of dumping the crappy cars onto some other part of the world.
Any more questions? Perhaps last one? Yeah, Alan.
Yes. The accent gives it away from the other side of the Atlantic. UK actually, in the Financial Services Markets Act, UK regulator has the power to be a litigator, so you're in the same space. We don't have a great class action tradition at all, as we discovered yesterday. But what we do have is regulators threatening firms with enforcement and then saying, and by the way, if you don't set up a functional compensation package, you will either go out of business, we will pull your license, etc., or we will just simply treble your fine. In fact, I'm really introducing the next session actually, because I know one of our speakers was involved in one of the cases where this happened. It does seem to me that one of the reasons why class actions are either stronger or weaker in a country may depend to some degree on the availability of external redress mechanisms. And you could argue very strongly that 420,000 cases a year going to the Financial Ombudsman Service in the UK is a form of class action, although it doesn't actually meet the technical description. So the US famously doesn't really do a very good dispute resolution mechanism for consumers at all, certainly not in the financial services area. Is there some sort of balancing effect going on here?
Yes, I think that if the state wants to regulate, it can do so effectively. There's a long-standing debate on, Hayek and many on whether excessive regulation leads to a great deal of capture and a special non-public regarding outputs. But this is not the panacea of this is the optimal way of doing it. It's just that the state is dysfunctional in the United States right now. Our government is largely dysfunctional. And so I'll give you an example. In my class that I teach complex litigation with Arthur Miller every other year, and last year I introduced a metaphor which became the dominant one in the course. I talked about the first time I went to New Delhi. And people warned me, be very careful, there's a lot of aggressive monkeys in New Delhi. And they come up and they can bite you, and because they're very similar monkeys to humans, the bite is very dangerous, high risk of infection. And they said, watch out for the monkeys. I get to New Delhi, there's no monkeys. No monkeys. I was kind of disappointed. I wanted to see the monkeys. But what happened to the monkeys? Somebody filed a direct action in the Indian Supreme Court. The Indian Supreme Court involuntarily joined the New Delhi Zoo Authority as a party and ordered the New Delhi Zoo to remove all the monkeys, which they did. And I asked the class, is this what we have become, a country where we have such a dysfunctional government that the only reservoir of functionality is the courts? And so we would even go to the Supreme Court to remove monkeys from any kind of local domain. And the answer is that that's sort of where we are, that these aggregated cases are a way of compensating for state dysfunctionality. Now, that's not optimal, but it's real. And so the question is, how are you going to protect people in this circumstance? About 10 years ago, and I'll just finish with this, about 10 years ago I was invited to address all the high court judges in Britain. And we had an informal session off the record. They just wanted to know about developments in aggregation in the United States. And they said, yeah, you can do this because you have Rule 23 and all that, but where's the authority? How conceptually do you ground this? Where are you getting this power from? And I said, from the prize courts. Right? The prize courts were the British Admiralty's way of resolving collective disputes. The prize courts were class actions. So I reject the idea that you haven't had this tradition in Britain. You've had collective resolutions when it's necessary to get all the assets in a place and to distribute them equitably. You've been doing it for centuries. You stop doing it for some reason, you become uncomfortable with it. Maybe it's the rise of Brussels, maybe this will change, maybe it's the rise of the regulatory state, I don't know. But I'm leery of the claim that this is not part of the British tradition. We got it from somewhere, and I think we got it from you.
Thank you very much, Sam. Now, guys, it's now time to break this wonderful crowd apart. So this will be lecture theater 2. Look at you have the schedule here, you haven't discovered that. This will be lecture theater 2. Lecture theater 1 is just below us. You've got to follow the girls, our staff who stand outside, and they will lead you to lecture theater number 1.
Excellent.
Oh, thank you very much.
I have to say, you're the first person I've met who looks younger in person than the
Guys, we are starting right now, please. There is no break at the moment.
Two things. Number one, I did a canned food litigation, contaminated canned foods. Exactly what you were speaking about. Litigation
והיה עוד אחד.
Yeah, but there's sometimes when they're not safe, they still ship them.
They still ship it.
אתה יכול לזהות אותו פה, אתה זוכר אותו? תביא אותו לפה, אני רוצה להראות.
He is, yes, is he the one who's yes, he's a cousin. Okay. So is Avi Isacharoff. So
This is a Bukharian name.
yes,
I went down with Angela Isacharoff.
Okay.
Do you know the Isacharoff?
No, I don't.
Okay.
No, but Jeremy's is a cousin. As is Avi.
Yeah, and another fellow went to the Foreign Service.
Excuse me?
Mark
I want to be sure your presentation.
Yep, other places.
Can you see on the screen? Can you see on the screen?
Yes.
This one?
First one will be. Yeah, it's there.
You recognize it?
Yeah, it's 2 down from where you are right now.
This one?
No, really, right there. When do we need to prep? Do we need to
Okay, open you.
That'll be the first one.
shorter because I know we're supposed to finish at 10:40.
Just a moment. Just a moment.
I don't want to be unkind to you, but yeah, a little bit.
Okay.